Another story we want to look at is, of course, the one coming out of the Supreme Court of Appeals. After a string of losses at the courts, the Supreme Court of Appeal has agreed to hear President Jacob Zuma's challenge of the 10 million personal legal cost order that were awarded against him. This, of course, relates to the former president's attempt to interdict former Public Protector Thuli Madonsela's state of a capture report. Now remember, this was back in 2016, and of course the case that he is making, he is challenging the remedial action of the public protector, as well as challenging the issue of the cost order. Questions have been asked on whether he will use his next court appearance to challenge the constitutionality of the Zondo Commission of Inquiry. For more, we're joined now in studio by News Africa's editorial contributor Karen Moore. Karen, it's good to have you with us.
Thanks for having me. It's
a challenge, of course, of that whole report that was released in October 2016. We're now in 2020, and President Jacob Zuma is still at it. Essentially, he is convinced that the commission was unconstitutionally set up because Thuli Madonsela put in her remedial actions that Chief Justice Mogoeng should appoint who will chair this Commission of Inquiry.
Well, essentially that's the point, because remember, in the normal course of events, it's the President's executive authority to appoint a commission, to define terms of reference, to choose the judge who would preside over that commission. And in the case of the State of Capture report, Thuli Madonsela effectively said it could give the appearance of a clear conflict of interest if then President Zuma, whose son Duduzane, his friends, the Gupta family, and he himself were very heavily implicated in the evidence that was collated in a report, if he was the person who chose the judge who would preside over the hearing. So she took that power out of his hands and said to the Chief Justice, you must be the person to appoint this judge. And Jacob Zuma, maintaining in his substantive review action, in addition to that interdict, which of course he abandoned, and then brought the substantive application to this remedial action, this idea that the power was being taken out of his hands, effectively saying that Thuli Madonsela's remedial action was unconstitutional, that what happened was unconstitutional, that it breached the principle of separation of powers. And that, he has, and what makes this, of course, very interesting is that he appears to be making the same arguments to Deputy Chief Justice Raymond Zondo, and hinting that he himself may bring a legal challenge of this nature to the constitutionality of the inquiry.
Of an inquiry that he formed himself. And it's the same line of argument, of course, that was dismissed by a full bench of the High Court, in fact, calling his whole entire review reckless and ill-advised.
Yes, I mean, their substantive point was that, he wasn't taking the allegations of corruption very seriously. And effectively, they agreed with Madonsela that they described his conflict of interest, or the appearance of it, as quote-unquote insurmountable. So they said, that it was just not appropriate for him to do this. But he's saying, I was not acting out of personal interest. I was acting out of genuine legal concern that what, for instance, may have happened in the state, the arms deal inquiry, where 150 million rand was spent, and then there was a legal challenge to it, and the way at which it was conducted, and how the terms of reference was applied, was successful. It wasn't defended by Ramaphosa, and that whole thing was thrown out. And he's actually alluded to that in his letters to Zondo, his responses to Zondo, to say, this is what informed my concern. I wasn't doing this out of self-interest, and therefore to award a personal cost order against me, which is like the highest form of judicial sanction. We're talking anywhere between 6 and 10 million rand here, against an individual who already has to pay back 16 million rand in legal fees, already has that 7 million rand bond on Nkandla, can't pay his school fees, and is looking at a potentially year-long corruption trial if and when he goes on trial with no money. That's a big factor as well. So it's not just about the effects of this personal cost order on him. It's effectively about saying to the appeal court, look at the reasons why I challenged this, and in making that evaluation, the court's going to ultimately have to determine in some way whether any potential legal challenge that he may bring in the future, if he does or someone else does, we don't know, could have any kind of substance to it.
So in essence, he is, of course, also challenging the fact that the court dismissed his late filing of his appeal.
Yeah.
He is also appealing, of course, the decision to refuse him leave to appeal and the personal cost itself.
And, you know, he's at the same time, he's trying to challenge the dismissal of his permanent stay of prosecution application in the Supreme Court of Appeal. He's seeking to challenge the court ruling that forces him to pay back the 16 million rand in legal fees, cuts off his future legal funding by the state. He's also seeking leave to appeal there. So there's an amalgamation of cases that he's dealing with. He is currently now, you know, in a situation where he's facing the possibility of being subpoenaed to the Zondo Inquiry. He's filed a very angry response to that, said to the Deputy Chief Justice, well, you must meet with my doctor and then understand what my medical condition is, because I'm not doing this because I'm uncooperative, I'm in fact sick. So all the kind of walls are coming around, but this cost issue is very important because it will link back to his unhappiness over the formation of the Zondo Inquiry. And the important thing to remember, Thabo, of course, is that he sought to appeal the ruling that dismissed his review. And President Cyril Ramaphosa, 2 months after the former president was forced to resign, withdrew that. So that appeal was sort of left in the ether. It wasn't ever, it was left in the hands. The High Court ruling was the one that stood. Yeah. And one doesn't know what other courts would have done with it. And because he's raising this issue of constitutionality, he's very much throwing a hint that this may well end up in the constitutional point, whether it's by him or one of the kind of individuals who are supporting his stance.
This would mean then the Zondo legal team is watching this very carefully.
Of course, because they have to be. I mean, we know that they filed a substantive response to Jacob Zuma's response to them, where he made, you know, he hasn't just attacked the way in which the commission has been set up. He's attacked its integrity. He's attacked, you know, the very soul of what it's trying to do, and insinuated all kinds of things. We know that he did that July last year when he went to go and testify. He was very angry about the way in which the commission had conducted itself, essentially suggested it was part of a deep-rooted plot orchestrated by foreign intelligence agencies that has been going on for at least 3 decades against him. So, you know, this is really a fight to the death, and Jacob Zuma has absolutely nothing to lose. So when his lawyers appear in court on the 26th of March, this is going to be fireworks, and the court, it's going to be fascinating to see how the Supreme Court of Appeal deal with this issue of this inquiry, which is obviously at the heart of this whole matter, but is being presided on by a judge. Hundreds and millions of rands have already been spent, and they're going to need to just be very careful and considered in their evaluation, but ultimately need to make a determination on whether in making those challenges, Jacob Zuma was acting solely in his own interest, or whether he had a valid legal basis for doing so.
One of the other arguments, of course, is I was actually acting to help the inquiry, because it's going to be confronted with this legal challenge at the end. But one of the other issues that he raises is these remedial actions were unconstitutional because essentially the public protector did not finish her work, and she was pretty much passing the buck to say, inquiry, do my work that I could not finish, and therefore she could not have come up with remedial action, because remedial action is born out of a completed investigation.
And that's a very interesting point, because of course it exists in the political dynamic of her leadership, Thuli Madonsela's leadership, being handed over to Busisiwe Mkhwebane. That was one of the features in the case, was that the initial case, Zuma had suggested that the investigation should actually be completed by Busisiwe Mkhwebane. And at the time, she had said she needed in the region of about 30 million rand in order to do so. We know that she filed a response to Deputy Chief Justice Raymond Zondo's application to extend the life of the commission, and she'd said one of the concerns that she raised was the amount that had been spent already, and that seemed to be an allusion to the kind of resource constraints which she had, but which he does not have. So, you know, there is a dynamic there of, well, why didn't you simply hand it over to Busisiwe Mkhwebane? But given the kind of averments that have been, you know, alleged against her about serving particular factional interests, bias, lack of competence, impartiality, you know, you can see why, you know, that will also again be a very fascinating dynamic that plays out in this court case, because that again is going to be an issue that is raised. So it's not just about the money here. It's about the public protector. It's about the Zondo inquiry, and it's about Jacob Zuma trying to very much legitimize decisions that he took, where he says, I was very much in favor of appointing a commission, but I just thought that it would be legally vulnerable if it was done in this way. Of course, the DA, which is opposing him on this, and his other detractors will say that he was acting completely out of self-interest, and that it was just yet another manifestation of his Stalingrad strategy of going to the courts to avoid the inevitable.
And of course, another important one is the one that, as you're saying, the DA part of this case, and the EFF also part of this case, and they've raised the issue of the president's prerogative, saying, well, there's no such thing as unfettered power, where especially you are an implicated party in the matter, to then allow you to appoint a body that is going to investigate you.
And this is not an unusual argument. Remember with the Mxolisi Mkasana matter, where Jacob Zuma, there'd been a settlement agreed to, I think it was in the region of over 15 million rand, for the then National Director of Public Prosecutions to walk away, where the court said, you know, that was unlawful, and that the appointment of Sean Abrams was in fact also unlawful because it was a consequence of abuse of power, and that, you know, the process in terms of the appointment or the replacement of Sean Abrams should be presided over by then Deputy President Cyril Ramaphosa, because Jacob Zuma, facing as he was at that stage the prospect of a corruption case, was conflicted, or had the appearance of being conflicted. And that's what the court looks at. It's not about a hard and fast rule of, are you definitively conflicted? It's about, what does it look like if someone who is facing trial then appoints the head of the National Prosecuting Authority? What does it look like if someone who is implicated very heavily in allegations of state capture, who is at the center of this whole thing, is the person who chooses the judge who will preside over an inquiry? And unfortunately, the Soweto example that the former president refers to with the arms deal, where it was very much dismissed as a whitewash that was, you know, designed to not look the other way in terms of the implications of corruption linked to the state, to the arms deal, you know, is an illustration of how those kind of things can play into public consciousness, and whether, you know, the public accepts that something is a bona fide appointment, a bona fide inquiry, or not.